And things are recording, so mics are live. We have 3 attendees in so far, 4, 5. Just give it a couple more seconds. We're about halfway through the attendees.
Sure.
We have a couple people that might turn in late, but why don't we go ahead and get started?
Okay, great. Thanks, Steve. Hi, everyone. My name is Chrissy Mann, and I am on the Maine Trial Lawyers Association board. And today we have asked Alicia Curtis and Miriam Johnson to put on the CLE for you regarding medical records vendors, the new act, and Cioxx issues that are going on right now. I'm going to mute myself in just a minute, but before I do, I want to alert all the attendees that there is a question and answer, a Q&A box at the bottom that you can ask questions there. We are going to hold questions till the end of the presentation, but I will be moderating throughout this and taking down any questions that come in. So without any further ado, I will let Miriam start.
Great. Hello. So we're going to really be doing a very sort of a beginner's guide to the HITECH Act. I'm going to start by going over some basics and sharing some practical advice. And then we're going to switch to Alicia, who's going to share some more complicated information about a recent Cioxx ruling and the Cures Act and how those intersect. And then we're going to switch back to me, and I'm going to finish up by giving you some more practical information about how you can be responding to medical records vendors if you're not getting the records that you want or you think that you're being overcharged. So let's go ahead. I'm going to start by making sure I can share my screen, start with the slides. Okay, I think that is just a little bit slow. Can you see my screen? Okay, great.
Yes, we can.
Okay, great. So as a very, very basic overview, one of the questions that I get frequently is, wait, what is the HITECH Act? I feel like I've heard of it. I don't really fully understand what it is. Essentially, the HITECH Act was something that was passed in 2009 to update or modify HIPAA regulations. The piece you need to remember is that they are both administered by the Department of Health and Human Services. Part of the goal of the HITECH Act was to expand an individual patient's rights to access their own electronic medical records. So it's part of this transition to be keeping medical records electronically as opposed to just a paper record. Part of the legislative intent behind this HITECH Act was to eliminate the barriers between patients and their records. So the theory is that patients should be able to request their records. They should be able to get an electronic record, and they should be able to get it quickly. Generally, what that translates to mean is within 30 days. And an electronic record is simply the record that, as we know, they're keeping records electronically now. They should be able to transfer it onto a CD, onto a thumb drive, or give people access through a portal. We are generally seeing the CD or the thumb drive a lot of people have realized that the portal, they may exist, but there's not a lot in there. All right, I'm trying to move to the next slide here. There we go. So the key information in the HITECH Act is how much should my records cost? So essentially, you know, this is, I'm sharing the language of the statute with you here. The fees are not absolutely specified in that there's not an exact dollar amount. What the language is that it needs to be a reasonable cost-based fee. So in other words, they can charge for the labor involved in copying the information onto that disk or thumb drive. They can charge for the supplies, so whatever the cost of that CD is, and then they can charge for postage to get it to you. They, in theory, they should not be able to charge beyond that. So what we had been seeing was typically we would be charged $6.50 for a long time, up until just this past January. $6.50 was the magic number. And we sometimes, you could prepay, send your $6.50 in, you would get the disc with the medical records back. That was the magic number. As Alicia will get into, that's no longer exactly the magic number, but the premise behind that as to how that came about is still the same. That $6.50 came from, there was a DHHS advisory decision in which they stated that $6.50 was an appropriate amount. And so whenever anyone was challenging a record or requesting a record, they could cite to that advisory decision and say, what, you know, you already said $6.50 is the appropriate amount. So here's my money, or I'm refusing to pay beyond that. So the question has become, what is a reasonable cost-based fee? So in other words, how are you going to know if you're being overcharged? You request your records under the HITECH Act. How are you going to know if it seems like it's too much, if there's no longer that $6.50 keyword that you're looking for? So you really need to go back to the language of the statute. If the $6.50 no longer applies, what is a reasonable fee? How will you know? And the language of the statute remains. They can charge you for labor, supplies, and postage. You know, I hate to quote Justice Stewart on this, but, you know, in regards to how will you recognize pornography, you'll know it when you see it. The same thing. If you get medical records, you get a disc with your records, and you get a bill for $800, you're going to know it when you see it. So there have been, you know, I have heard from attorneys in other states who have gotten their records back with bills for thousands of dollars, you know, $8,000, $10,000 bill. We have seen some absurd bills, not quite in the thousands and thousands of dollars realm, but things that we would get and say, that's ridiculous. There's no way you can say that labor, supplies, and postage comes to hundreds of dollars. So that's something, you know, we need to be aware of that. One of the key things to remember, though, is that in Maine, we have the statute that sets a maximum amount for how much you can be charging for electronic records. So if you look, it's in Title 22, I have the language here. I know the slides will be available for you afterwards, so I think they can just be sent to you. So, you know, the first part of the statute, I think, has a maximum of $250 for paper records. This part of the statute has a maximum of $150 for any electronic records. So you should have that as your very baseline. When you're getting a bill, if you get a $500 bill, if you get a $151 bill, you should have, you know, that should trigger something in your mind of that is beyond the state statute. That's more than what they can be charging. So that's sort of the how much should records be costing. you know, they should be costing anywhere between $650. I'm going to say, you know, and they definitely need to be under $150 because that's within the main statute. The question is that I think everyone gets to decide for their own firm is, you know, what makes it worth it for me to follow up and to be requesting these records under this act. So when you're requesting records, the reason why you may want to be using the HITECH Act is because it should be inexpensive, it should be fast, and it should result in electronic records. I don't know how many firms have switched to requesting all of their records electronically. I know that a number of you are in that process. So when we request these, you know, the next question is, so how do I request records when I'm doing this under the HITECH Act? I know everyone has their authorizations. This is slightly different in that it really needs to be coming from the client, from the patient. So the key bullet points to remember are you need to keep it very simple. You don't want to have a long, flowery authorization or be including a letter that has all sorts of legal citations. This needs to be as though it is coming from the client. So think of what your client, if they had the magic words, how they would be requesting it. Keep it simple. They need to sign it. You don't need to be including cover letters or fax cover sheets. Remember, this is coming from the client. The magic words that they need to include are that they are requesting their electronic copy. They will be willing to pay labor, costs, and postage, and a quick citation to the relevant statutes. They can just say, under this act, I am requesting my electronic medical records. This is the sort of thing that we request. You know, dear so-and-so, I'm making this request under the HITECH Act. I would like an electronic copy of my records. Please electronically transmit this to. It can either be to the patient or the client themselves, or to an attorney, and we'll talk a little bit more about that after. And then will be reimbursing or willing to pay for the labor, the costs, and the postage required for this. So one of the things that has been happening lately is, and I'm going to switch to Alicia shortly, is there have been some changes in some recent rulings. So this is something, this notice that I have in the slides dated January 28th of this year, this has been coming, any records that we're requesting from a third-party vendor, I think specifically, I don't think it's just specifically Cioxx. I think we're getting this from all of our medical records providers. They're sending this notice about your rights of access to health records. And they're basically telling you right up front, you may be billed rates that are not consistent with the HITECH Act. Why is this? And they're alluding to the cases that Alicia's going to talk about, which is a Cioxx decision. And they're saying that when you are requesting records for a patient and you're asking for it to be sent to a third party, such as a law firm or an insurance company, they are going to try to make the argument that the HITECH Act does not apply, or that certainly that the prior $650 fee does not apply. We are very much of the opinion that the underlying theory behind the HITECH Act is still in place, and that the fact that you're paying for labor, cost, and postage remains. So I'm going to switch to Alicia here, who can fill us in a little bit more about the recent changes that have been happening, the recent rulings, and the intersection between the Cures Act and those recent federal decisions. And then we're going to come back to me, and I'll talk a little bit more about, so what do I do when I request records and I feel like I'm being charged more than I should be?
Thank you, Marian. So I just, before I launch into my slideshow or get in too much depth about the Cioxx decision, what is it? Does it really mean what the record companies say it means? I just want to just go back and review briefly the different sources of the law that we have here, because the Cioxx decision really talks about those different sources. So just to recap, we have the HITECH Act. One thing that the HITECH Act did is it broadened the client's access to medical records by allowing the client specifically to request that medical records be sent to a third party. So it allows the client to direct medical records to their lawyer, to an insurance company, to a third party, and that's allowable under the HITECH Act. And then you also see, as another source of law, you see the regulation that Miriam put up, the 45 CFR 164.524 regulation, which says that the cost of those medical records should be a reasonable cost-based fee with labor, supplies, and postage. So now we get into the Cioxx decision. I'm just putting my screen up here. Hopefully we should all see that here. So Cioxx is, as you probably know, one of the larger medical records vendors in the country. They brought a lawsuit challenging different aspects of this law. One thing they challenged is they challenged 2016 guidance that was promulgated by Health and Human Services, the Department of Health and Human Services. So this was something that's up there on the HHS website. It's not a statute, it's not a regulation, but it matters because HHS is the agency that enforces the HITECH Act. So HHS's interpretation of what that act means and what people should be doing obviously matters, because they're going to get Cioxx in trouble or get the medical record providers in trouble if they're not following HHS's interpretation of the law. So they published this 2016 guidance. HHS published a 2016 guidance. And under the 2016 guidance, both first party and third party requests for electronic medical records are subject to that same cap. It's the $6.50 kind of magic fee, or the limitation that it has to be a reasonable cost-based fee, including labor, supplies, and postage. The 2016 guidance says both the first party requests and the third party requests subject to the same cap. So it doesn't matter where those records are being sent. You could send them to your aunt, you could send them to your lawyer, you could send them wherever you want, but it's still subject to that cap. Cioxx challenged that. Cioxx argued that this went beyond the fee limitation in the HITECH Act, and in fact, it violated the HITECH Act. So the relevant language in the HITECH Act here is, it says, the statute itself says that in applying 45 CFR section 164, so that's the regulation that Miriam showed you about the reasonable limitation on fees, any fee that's provided to such individual shall be no greater than the entity's labor costs in responding to the request for the copy. So the question here is, who is such individual? Does that mean only that this fee limitation only applies if you're supplying a copy of the electronic medical record to the patient? That's what Cioxx is arguing. Cioxx spent a lot of time in that decision arguing that, you know, yes, it's fine for people to have rights to their own medical record for their own use, but if you're sending it to a law firm or an insurance company that's a for-profit entity and they're commercially benefiting from that transaction, that was Cioxx's argument, and we shouldn't be subject to that same fee cap. So that was their position going into the litigation. And here, just so you can see it, this is the 2016 guidance. It's still on the HHS website, but I'll show you a little bit later how it's been changed. This is the 2016 guidance, and it says specifically, if you're providing protected health information to the individual, the same fee cap applies when an individual directs that protected health information be sent to another person. So this is HHS specifically saying the first party fee and the third party fee, they're both subject to the same cap. And that's what Cioxx challenged. Hang on. Okay. So the federal district court in the District of Columbia actually agreed with Cioxx. They said the 2016 guidance that I showed you that HHS put up on their website, it violates the Administrative Procedures Act. They said it went beyond interpreting the HITECH statute. They said the HITECH statute is ambiguous about whether its cap on fees for first party requests also apply to third party requests. So remember, that was the language I saw you before, and I showed to you before, and it's arguably a little bit ambiguous about who does this refer to, such individual. So the Cioxx court said it's ambiguous, and they said the regulation that we showed you before, 45 CFR 164, really only applies to first party requests. So they're saying HHS really just made it up. They made up this idea that the first party request and the third party request are subject to the same fee. They're saying you made that up out of whole cloth, and because you did that, because you created a new rule, you should have gone through the notice and comment process. You didn't, and therefore you violated the Administrative Procedures Act. So what that means is, it means that this provision in the 2016 guidance that says third party requests and first party requests are subject to the same fee cap is gone. But the Cioxx court did really leave it open for HHS to come back. They could promulgate a new regulation. They could go through a notice and comment process, and that regulation could become the law of the land. So that's something to look out for that could be coming. The Cioxx court definitely left the door open for that. Cioxx wanted to say that the 2016 guidance really actually violated the HITECH Act. And the Cioxx court said, not so fast. We think it's ambiguous, and we don't know. We think maybe if HHS promulgates this and goes through a notice and comment process, things will become more clear. It could all be fine. We're not going to make a judgment about that now. So that was the main holding in Cioxx v. Azar. The other thing, you just want to note, it's not a big thing, but the Cioxx court did also say that federal regulation that expanded the idea of a third party request to paper records. So it was a federal regulation that came out that said, just like the patient can direct the provider to send electronic medical records to third parties, that should happen as well with paper records. The Cioxx court said, no, not so fast. That doesn't apply to paper records. So all that means is that for paper records, we just go back to where we were. You need a HIPAA compliant request, and you send the request out from the law firm with the HIPAA release, kind of in the same way that we did normally beforehand. So after the Cioxx decision, there was a lot of just sort of people on edge wondering, is the government going to appeal this decision? Will it be allowed to just become final? Will it become the law? What's going to happen next? The HHS, the government, never appealed the federal court's decision. So Cioxx v. Azar is the law. But HHS could, at some point in the future, promulgate the same language as a regulation with notice and opportunity to comment. So that might come later. There might be a fix that comes later. But what you'll see now, if you go on the HHS website, what you'll see now is you'll see that the 2016 guidance has this little warning on it, like a little warning label. And it says any provision within this guidance that has been vacated by the Cioxx health decision is rescinded. So that means that even though you see that language up there on the HHS website that says first party requests and third party requests should be treated the same, they're subject to the same fee cap, that's not the law anymore. That's been rescinded. And HHS did in fact publish this notice. And I think the notice is what Cioxx and the other medical record providers are now sending you in the mail when they send you that notice and say, you know, why am I be charged a fee that's not in compliance with HITECH? Well, this is why. So HHS has clarified in this notice that the fee limitation in 45 CFR 164.524 only applies to an individual's request for access to their own records, and it doesn't apply to the request to transmit records to a third party. So HHS is sort of just, in some ways, kind of given, for now, apparently given up on that. I mean, that they can see that that's the effect of Cioxx, and that's their official position about it. So that leaves us sort of wondering, like, what next? Is there any hope? I mean, certainly our position is that the premise behind the HITECH Act and the idea that the fee has to be reasonable and cost-based is still in play. We also have another act that was passed a little while ago, but is the final rule under that statute has just been adopted and is about to be implemented. And this is called the Cures Act. And the question is, some people I think are wondering, does the Cures Act actually cure Cioxx v. Azar? To what extent is this going to fix our problems here? So the Cures Act, the purpose of the Cures Act is to encourage the development of health information technology and also to allow patients to access their medical records through electronic means very quickly and easily. So that sounds right away like it's going to be helpful. The Cures Act also creates this concept of information blocking. And the goal is to prevent, and information blocking is anything that prevents or discourages patients from accessing their electronic health records. So you might think charging an exorbitant fee for your electronic health records would be information blocking. I mean, that sounds like that could be helpful there. The final rule, so the regulations under the Cures Act were adopted in May, they took effect in June, and healthcare providers have to start complying with this in November 2nd, 2020. So this is coming up soon. And the Cures Act and the regulations under the Cures Act are a little convoluted. So I'm not going to walk them through you in sort of exactly as they're drafted, because they create this idea of information blocking, then they create an exception to information blocking. So it's kind of a safe harbor for things that are not information blocking. Then they have an exception to the exception. So just to avoid using a lot of double negatives, I'm just going to sort of tell you the end result of it. The end result of it is that as part of the safe harbor, what it allows is that providers may charge fees that are reasonably related to the actor's costs of providing access to electronic health information to or at the request of the person or entity to whom the fee is charged. So to me, this confirms or reestablishes a reasonableness limitation on third-party requests, because the person or entity to whom the fee is charged, that's us, that's the law firm, we're being charged the fee. And our fees for access to electronic health information have to be reasonably related to the actor's costs of providing the access. And the actor is either the healthcare provider or medical information technology, you know, a health entity like Cioxx that simply just retains the health records and sends them out to people. So to me, this is a reasonableness limitation. It's back in play. This is something that we can cite if you want to push back against what looks like an unreasonable billing. It's language that's right there that we can cite. The other thing that the Cures Act regulations do are that they strengthen the fee cap for first party requests. So there's already that fee cap in 45 CFR section 164.524. They strengthen that. They say, yes, and also that's also information blocking. So, and information blocking is subject to a monetary civil penalty. So there is kind of a hammer, not, or a penalty associated with information blocking. They also have a provision that seems like it might be helpful on its face. It says providers are not allowed to charge any fee for electronic access to medical records. And you might think, well, that's what we're doing here. If we want electronic medical records, that's electronic access. That's what we want. You shouldn't charge any fee. But if you look at the definition of electronic access, it's something where the information is available at the moment you request it, and there's no manual effort required to fulfill the request. So that's the patient portal that we all know and sort of don't love. I mean, it's there. It's usually not very helpful. There's usually not a lot of information in it. I think that one of the purposes of the Cures Act is to make sure that the patient portals actually contain more information and that patients can access their entire record through the portal. And when that happens, when and if that happens, I think the portal then could become something that's helpful to us. And certainly these regulations provide that they cannot charge any fee to access that regardless of who accesses it. So that's something to kind of think about in the future, maybe as the portals become more helpful, that's something we could turn to. And another helpful thing about the Cures Act regulations are simply that it provides another agency or entity who's going to enforce information blocking. So previously, if you had an unreasonable fee for medical records, you could go to the Office of Civil Rights and they enforce HIPAA. They could enforce that. It was a little bit of a procedure to get, I think, it's a decision you have to really think about. Do you want to take the time to do that? Information blocking under the Cures Act and the Cures Act regulation is going to be enforced through the ONC, the Office of the National Coordinator for Health Information Technology. They have something on their website, and I checked it out. They have a little link there, and it looks like they make it very easy for you to report information blocking. It's like a very easy little form. I haven't done it, but it looks like it would be easy to do. And so that'd be another thing to think about if you're getting an unreasonable fee, a fee that's not related to the cost of providing the medical records, that you could report that to the ONC. And the providers will have, they'll be facing a significant civil penalty for information blocking. So it's something that they hopefully will pay attention to. So that's sort of what happened with Cioxx and the Cures Act. I think, I guess to sum it up in just a few words, essentially Cioxx, the result of Cioxx is that third-party requests in electronic medical records that are be sent to law firms are no longer under that magic 650 figure. Arguably, they're still subject to a reasonableness limitation. Of course, they're still subject to the state statute, the limitation in the state statute. Once the Cures Act starts to be enforced on November 2nd, 2020, we definitely have language saying that those fees need to be reasonable. And we have another mechanism in which to report unreasonable fees. So that's sort of my sum up of that. And I think my last thought to pass along, and Miriam is going to talk about some strategies about this, is to think about the difference between the first party request and the third party request. And certainly the court in the Cioxx decision spent a lot of time talking about that difference and about why attorneys and insurance companies, which are for-profit entities and are using these medical records for commercial reasons, why it's okay to charge us more. But I think if you drill down there, to me, that doesn't seem like a very valid distinction, because we're doing this for our clients, and we act as fiduciaries for our clients. We act as agents of our clients. We're accessing their records at their direction and for what's essentially their purposes. So I think Miriam has some strategies in terms of thinking about, can we get our requests put back into the category of first person requests? Why do we have to be considered the third person request? Maybe there's a way to get back into that first person request category. So those are my thoughts.
Thank you, Alicia. That's very helpful. I took notes. All right, let me make sure I am sharing my screen again. Are you seeing my slides here with the blue box? Okay.
Yes.
Great. Okay, great. So let's move on. So the next step then is, so let's say you've created your request, you've requested electronic records under the HITECH Act. If all goes well, you're going to receive an electronic record within 30 days and you'll be charged a reasonable fee. Maybe a bill shows up for $20. Great. Seems reasonable to you. You pay it. Everything's fine. Frequently, what we have been seeing is fees that seem to fall into the unreasonable category. You know, as I said, you're going to recognize that right away. If it's something that's above $150, you can respond and simply cite that state statute that I already have in the slides. Furthermore, you can also explain, you know, why even under the HITECH Act, despite the recent Cioxx decisions, but also under the Cures Act, as Alicia has said, why they still need to be producing records under a reasonable, with a reasonable fee. So number one, the real big message I want people to take home is respond. You know, when you get a crazy bill, don't just sort of grumble and pay it, because that also supports these medical records theory that, you know, well, everyone else pays it. So, you know, we want people to really respond. So number one, one of the first things that you can explain is that the patient is bearing the cost for their records here. You know, as Alicia said, you're acting as a fiduciary, you're requesting these records on behalf of your client. But also, you know, when we sign a fee agreement and we decide to represent someone, it is very clear from the get-go that, you know, we will certainly charge a fee, but also our client bears the cost of those records. We don't just eat that. We don't pay for that. That's the client's money. And I think most firms operate that way. So, you know, if our client is being charged $10 or our client is being charged $150, that's money that's coming out of our client's pocket. So we're really acting on behalf of the client. So here's another piece of background that I want to share with you, because I think this is part of an argument as to why we have a strong argument that they should be producing records and charging only a reasonable fee. So there's a system that used to be called the EHR, or Electronic Medical Record Incentive Program. I believe it's now called the Promoting Interoperability Program. But this is a federal program that provides funding to healthcare providers, hospitals, if they are agreeing to implement this use of electronic health records. I have in there electronic medical records. It's electronic health records. It's all the same thing. So under the HITECH Act, the providers have to show that they are making meaningful use of electronic health records in order to qualify for this federal funding. This is administered through Department of Health and Human Services, through Medicare and Medicaid. So this is sort of a lengthy slide. This comes from the CDC website, but this is explaining what meaningful use is. And it is one of the ways that it is measured, as I have here, that a little bit above here, it's not highlighted, but they need to show that there is adequate privacy and security protection for personal health information, but also that there is accessibility. So what I've highlighted here is stage one. They have to establish the requirements for the electronic capture of data, but also they're including providing patients with electronic copies of their health information. And they're not specifying that that is only through a portal. Our interpretation is that that might be through a portal, but it's also upon request. So they are being graded on this. They have assessments periodically. And one of the things, you know, this is direct from the DHHS website of how they're calculating a provider's grades. One of the key ways that you can earn points is to be providing patients electronic access to their health information. One of the ways that they can do that is through the patient portal. One of the ways that they can do that is by providing electronic records to a patient upon request without that information blocking that Alicia referred to under the Cures Act, by charging a reasonable fee. This is the data for Maine. This had to be implemented by the end of 2015. As you'll see, 100% of urban hospitals and 100% of rural hospitals. So we interpret that, our understanding is that that is all of the hospitals in Maine. So that is some good background information to have. I will refer back to this in a minute here as we talk about one of the things to really bring to their attention. So there are also a couple of ways that you can that we're having conversations about to get out ahead of the problem. So when you're requesting medical records, there are a couple things to consider. One is prepayment. I know of somebody recently who submitted prepayment with their HITECH request, and I believe they paid the $650 and said, you know, in their request, I am enclosing $650 as what I consider a reasonable fee. We consider that when you cash this check, you're considering this to be payment in full. And they got their records with no further bill. So that is one option to consider. The other one that we're talking about is to consider a power of attorney. And I know that there are some other firms that have just started doing this. And this would be to include a power of attorney with the HITECH request that is clear that you have authorization to be acting on their behalf for the purpose of requesting medical records. So again, as Alicia said, you're really making it clear that you are acting on your client's behalf. This is not just because we as a firm are interested in these medical records. This is on the client's behalf. So if the medical record vendor is not responding to all of these well-reasoned arguments, there are a few things to do. So first, you want to go through your list. You want to, as I say here, pull out all the stops. Start by talking to the medical record vendor yourself. And for staff members here, that might mean getting the lawyer involved. Unfortunately, we know that sometimes they respond to someone with that title after their name when they won't respond to the equally competent staff members. That have you notified the hospital that their medical record vendor is violating the law? That is frequently a helpful step. Have you talked with their legal counsel? Usually that will resolve the problem. If not, you know, in the past, the complaint has been, you can file it with the Department of Health and Human Services, Office of Civil Rights, and you can always copy your state attorney general. As Alicia said, under the Cures Act, it sounds like that's actually the ONC, the Office for the National Coordinator of Health Information Technology. We have not moved to that yet, but it sounds like it's in our future. So I have to say, we have never actually had to file a complaint with DHHS. I have gotten to the point where I have drafted a complaint of this is what it will look like. We're ready to send this letter out. And we have had a positive response from that. One of the real issues of when you notify DHHS, I think that really counts against a provider when I have just had that score up on the screen of those 40 points. That's information that's going to DHS. And not only is there a potential for fines, but they're at real risk of that federal funding that I referred to drying up, or that there are points against them on their next review. And that is one thing that we have found the providers really want to avoid. So that I think is a very a potent argument. So hopefully that gives you some practical information of where do I start with a HITECH request? How do I respond when I get this mumbo jumbo about Cioxx, and what do I do? And what happens if they seem to be charging me what seems like a crazy amount? We are happy to answer any questions. We've built some time in to respond to questions on your behalf. Chrissy, I don't know if you've received any.
Yeah, thank you both very much. That was very informative. I don't see any questions and answers yet in the chat box, but actually I was going to ask you, Miriam, the example that you gave just a second ago where someone prepaid for those records and sent in the $650, was that an experience from an individual's perspective, or was that a law firm that did that?
That was an attorney in private practice. It was someone who was working with us to forward a case, and said that they would be happy to request records on their own. And honestly, I think it wasn't, it was sort of an accident, but a very happy accident of they sort of heard that it was that amount, and great, we'll send it all in. And we were very happy and surprised to say, oh, look at that. There was no bill attached. They accepted full payment. So, you know, I had heard that out there of that's one of the theories of we can try this, we can try prepayment. And we hadn't tried it yet. So I was happy to see that experiment worked. It is a very small, you know, body of data of what I've heard. That's an anecdote. But I think that it's an absolutely, you know, it's a valid thing to try.
Interesting.
And we're having that conversation of, does it make sense for us to be doing that?
Yeah. In regards to the POA that you had mentioned, the power of attorney, have you been seeing, or in the example that you gave, was that limited in scope in terms of just to get, you know, just to utilize that power of attorney in this particular instance?
I would think so, yes. You know, in the conversations we've had, it would be specifically for this instance.
Okay.
Because I don't think we want to be sending in a power of attorney that's a lot broader.
Right.
So yes, you know, and we'd be happy to talk. I don't know if people have been sharing such, you know, drafts or templates, but we'd be happy to share.
Great. Actually, that is the question right now from someone who's participating, is that in addition to the slides, they're wondering whether Berman and Simmons is willing to share the forms that you use now to request records, including the POA and the actual request for Cioxx and ShareCare, et cetera.
Mm-hmm.
Okay.
Yep. Yeah. I mean, I've included the bullet points. Let me talk and see, because we hadn't had that conversation, but I can certainly see we do have the request. We have a template that we use that includes those bullet points, and then it simply includes after that basically the HIPAA information, what you would typically have on an authorization, a medical record request.
Great.
But I think we would be happy to send that out.
Yeah.
Done the power of attorney. Sorry, I'm not sure we've actually done the power of attorney. So.
Okay. Okay. Well, we'll wait to hear from both of you on that front. But the next question is, do you have any specific recommendations on language to use when out-of-state record vendors attempt to charge for billing statements? We continually tell them in Maine you cannot be charged for bills, but they still send past due notices.
I'll start. I'll start and you can jump in, Alicia. We have responded to that simply by referring to the statute. I know Alicia said that we were talking earlier before this, and I think she said that she had one. And I think it was honestly just a strongly worded letter citing to the statute and making clear what we would pay. Unfortunately, have an attorney sign it.
Okay.
Yes, I responded to one medical records vendor that said, we're going to charge you Pennsylvania rates because we're located in Pennsylvania. We don't care if your client got medical care in Maine. And I didn't have a lot of time to put into that. And I I wasn't able to find a great citation, but I just sent back a strongly worded letter and said, my client received care in Maine and you need to pay the Maine rates and this is the Maine statute. And I think that was the end of it. So sometimes persistence helps. And I'm sorry, I don't have a magic citation or anything beyond that.
Yeah, that's okay. Well, we really appreciate it. I don't see any more questions at this point, unless either one of you have any closing thoughts or information to share. I'd like to thank everyone that has come on to participate today. Let's see, I think we're getting one more question. Is the provider able to charge a fee to tell us that there are no records?
Ooh, that's a good question.
I don't think so. The reason why is because I believe there's language that says they can't charge for the cost of searching for records. I'd have to go back and look, but I think that's the language. They can charge for the labor costs for producing the records, but not for searching for the records. But I'd have to go back and look at that more carefully.
Great. Steve, is that a way that maybe once they locate that answer, we could send that out to the attendees of the presentation?
If I find
Yes, we
that, I'll
can
add
do
that
that.
to my slides.
Yeah. Great. Well, it's been about an hour. Again, we appreciate everyone's time. I don't see any more questions. So that will conclude our CLE for today. Thank you very much.
Thank you.
Thank you.